Good morning, ladies and gentlemen, fellow members of the New York City Bar Association, lawyers, law students, law professors around the country, and fellow citizens concerned about the rule of law. Welcome to the third session of the Rule of Law Forum of the New York City Bar Association. Our first session, which was held last month, was devoted to a general summary of threats to the rule of law in an age of disruption. Our second session dealt with checks and balances and threats to the checks and balances in our federal government system. Both of those sessions are available, have been recorded, and are available on the New York City Bar Association website. Today's session will deal with executive interference with judicial process and local law enforcement. Future sessions will be held on October 22, when we will look at the questions of respect for societal and individual rights in this age of disruption. And our final session on November 18 will address what the legal profession and what the citizenry can do to rebuild the rule of law in the United States. It is my pleasure to introduce to you as our moderator for today's session, Mr. Roger Maldonado. Roger is a member of the law firm of Smith, Gambrell, and Russell. He is the immediate past president of the New York City Bar Association. Before I turn it over to Roger, I'd simply like to thank once again our planning committee for this entire forum, chaired by Robert Cusimano, and with the assistance of former Justice Marcy Kahn and Jennifer Rogers and Josh Traytel, who have all contributed to the planning and realization of this program. Roger, it is my pleasure to turn the program over to you, and so that you can introduce our wonderful speakers. Thank you.
Thanks, Steve. Welcome to today's Rule of Law session on interference by the executive with judicial independence and local law enforcement. This session will explore the effects of executive disruption of several distinct justice systems: the civil and criminal courts, the immigration court system, and local law enforcement. Our speakers will explore the implications of executive interference with investigations and trials, castigation of individual judges and jurors, the deployment of military and/or federal forces in connection with local law enforcement, and the issuance of pardons without traditional due diligence for civil and military crimes. Professor Charles Freed will deliver a keynote talk designed to introduce the material for today's session, followed by more specific presentations by our other four speakers: Chuck Rosenberg, the Honorable Jed Rakoff, Professor Harold Coe, and Margaret Colgate Love. We will have a question and answer session after each speaker, and another general Q&A session at the end of the program. Due to prior commitments, Professor Freed and Judge Rakoff will not be able to participate in the general Q&A session. So please be sure to direct any questions you have for them at the end of their presentations. Questions may be posted via the Q&A button at the bottom of your screens. We will endeavor to pose as many of these questions to our speakers as time permits. The program is scheduled to run for approximately 3 hours, and we will proceed without breaks, understanding, of course, that participants will take whatever time off they may need as the program progresses. I am now pleased to introduce today's keynote speaker, Charles Freed, Professor of Law at Harvard Law School. Professor Freed has been teaching at Harvard Law since 1961. As the United States Solicitor General under President Ronald Reagan, he argued 25 cases in front of the Supreme Court, and later became an Associate Justice of the Supreme Judicial Court of Massachusetts. Among the cases Professor Freed has argued in state and federal courts was Daubert versus Merrill Dow Pharmaceuticals, in which the Supreme Court established the standards for the use of expert and scientific evidence in federal courts. Professor, the floor is yours.
Well, I'm not going to deal with the rather focused questions which the other speakers will deal with, but I'm going to deal with the general issue of judicial independence, because after all, in the end, that is what is at stake in all of these more specific contexts. And this is a bit of a meditation on judicial independence. We all think that's a great thing, but I'd like to begin by asking, what is judicial independence and why is it valuable? Well, we can begin by saying kind of the via negativa, what it is not, the polar opposite. The polar opposite sometimes goes by the name of telephone justice, which was the name given to it during the Soviet era, where there would be a trial or judicial proceeding, and the political powers, the party people, either beforehand or having been alerted that something of political interest was involved, would simply telephone the judges involved, or the judge or judges, and indicate how the matter was to go. That really seems quite awful. However, there is an entire conception of the role of the judge and of judging and of courts, under which it's not only not awful, but is right and proper. If you look at some of the Marxist, Leninist, Stalinist reflections on government, you see a role for the judge and for the courts, which is simply as an organ of administration. There's no sharp distinction. The judge is a bureaucrat, and the bureaucracy is intended to apply the party line in every matter which comes within their scope. And should it happen that a bureaucrat doesn't have a sufficiently instinctive sense of what that is, it is entirely appropriate for, as it were, the commissar to remind him or her what the job is. I think there's an awful lot of that also in the contemporary Chinese regime. But before you shudder too much at this notion of the judge, it's interesting that in a perfectly standard, and not only standard, but and more than benign, proper system, the civil law system in a country like France, for instance, the judge does have a bureaucratic mission. After all, the whole investigation of crimes is in its later stages under the control of the judiciary. So before you get too huffy about the Marxist view, remember that there are nuances here. And indeed, we've had a rather striking and rare eruption of just this kind of thinking in the Flynn case, because there, that really was almost a classic example of telephone justice. How it will play out, I do not know, but the reason, and I think it's hard to say, the reason I say this is telephone justice is because the rule under which the intervention took place, the Attorney General's telephone call, as it were, says that the action which was under consideration, the dismissal of the charges of somebody who had pled guilty to a number of crimes and was awaiting sentences, was permissible only with the leave of the court. Well, that would certainly seem to suggest that the decision is under some kind of guidance, lawful guidance, guidance of law, in the broad sense, I suppose, within the authority and the jurisdiction of the judge. Not at all was the claim of the Department of Justice, quite, how should I say, fulsomely argued twice, most recently before an en-banc panel of the DC Circuit. So, stay tuned. But that's an example of judicial independence on the line. Well, okay. So what exactly is judicial independence and why is it important? Let me go back to Lord Coke in the case of prohibitions. In that case, the king and his counselors asserted a jurisdiction to decide in a proceeding, in what one might call an executive agency today, of actually a matter of property law and of authority. It had to do with medical doctors. And the Chief Justice, Coke, issued prohibition there. And the king was outraged. He said, "What business do you have doing this? You think you're so great? You think you know so much? You think that you have some special competence? I am possessed of reason. It was God that had endowed His Majesty with excellent science." Coke responded, "Indeed, but these matters are to be judged not by natural reason, but by the artificial reason and judgment of law, which is an act which requires long study and experience before that a man can attain to cognizance of it." In other words, king, butt out. So you have the sense that judicial independence is warranted because the judge knows something that other people don't know. And those other people, those other branches of government, as it were, should not seek to override the exercise of that artificial reason of the law. That's a challenging notion. There's another expression of it, which comes from a different tradition, which I like. I like it very much. There are two hadiths. Hadiths are in the Muslim tradition, canonical recorded sayings of the Prophet. And here we are. The Prophet, peace be unto him, said, "Judges are of three types, one of whom will go to paradise and two to hell. The one who will go to paradise is a man who knows what is right and gives judgment accordingly. But a man who knows what is right and does not give judgment according to that will go to hell. And a man who gives judgment for people when he is ignorant of the right will go to hell." That's a fairly strong statement, but I think one which, Jed, should be taken to heart. And then there's a second hadith. The Prophet said, "If anyone desire the office of judge and seeks help for it, he will be left to his own devices. If anyone does not desire it, nor does he seek help for it, Allah will send down an angel who will direct him aright." Consider that, Judge Barrett. Well, okay. So we have here this notion of the judge. The judge is something special. And needless to say, we make every effort to support that notion. We put judges in robes. We put them on a dais somewhat higher than where the ordinary mortals who are arguing a case are located, from which they argue it. So they are judged, are respected in the sense because they are meant to stand apart. Well, what is it that judges know, and why do they stand apart? And what, in other words, what's going on here? Well, I cannot refrain from quoting another hero of mine. At the very beginning of the theory of justice, John Rawls writes, "Justice is the first virtue of institutions, as truth is of systems of thought." And the two, of course, he doesn't, it is I speaking now. The two we have seen are closely related, truth and justice. The special knowledge, think back to Cook. What is it that judges know? Well, one of the things in constitutional law that has been said, and badly said, I think, mistakenly said, that in areas where there is doubt, where the text, meaning of the text is in doubt, and of course constitutional law is the seat of those kind of areas. And how could it not be? A document drafted in 1787 has and endures, amended not very much, obviously has got to require interpretation. And the view which is often stated, more often now than in the past, is this is not a normative or a question of justice, it's a question of truth. And the truth is a historical truth. In other words, the question of judgment and sometimes morality is not what the judge does. The judge must find the truth, and the truth is a historical truth. It is the original meaning of those who wrote the words. As to that, I think the definitive answer comes from a great New York lawyer who then went to the Supreme Court. Just what our forefathers did envision or would have envisioned had they foreseen modern circumstances must be divined from materials almost as enigmatic as the dreams Joseph was called upon to interpret for Pharaoh. In other words, it is both more difficult and more indefinite than that. But the trouble with that account is that it makes difficulties for both the prophet and for Lord Cook, because knowledge, what is this artificial knowledge? Isn't that what the devotees of text and original meaning are gesturing towards? Is that not the truth according to which the judge had better, at pain of hell, judge? Well, no, it can't be. It is something else. It is something more capacious, and yet it is not something which is wide open. How can that be? What can it be? That is the dilemma which judges face, and if they have the right point of view, solve. And it is because they face this dilemma, and if they are good judges, visibly seek to resolve it, that we respect them, that we call them your honor, that if you have been a judge, that, as I have been, that honorific, at least in some minds, just carries on forever. You are judge. Certainly to my former law clerks, I am. It's like once a priest, always a priest. So what is it that's going on? It is the remarkable tension between having an open mind, but not an empty mind. The judge performs this amazing intellectual task of having a mind open to argument, truly open to argument. The lawyer or party appearing before that judge is made to feel that possibly he or she can reach the mind of the judge and move the judgment of that judge. That's what it means to have an open mind, but not an empty mind. That is the knowledge part of the Muslim Hadith, to judge according to knowledge. Well, what is the knowledge? The knowledge is the knowledge of the law, but that knowledge, as Robert Jackson in what I quoted now is pointed out, is not a simple matter. It is not a text or just a text. It is something more. It is the text and the traditions and the moral aura around the text, the precedents, and somehow, indeed, the convictions of the judge. Well, so an open but not an empty mind. In that delicate balance, you can see how destructive, how corrosive, how corrupting it is if one seeks to influence that judgment by something other than argument, an argument appropriate both in circumstance and content to the law. That is why a judge supposedly is not supposed to be reached other than by argument in briefs which are open and public to both sides. It was, and I think amicus briefs are very, amicus parties are very careful about this. They should not cite material which is not publicly available, nor is it appropriate when you meet a judge at dinner or on the street to make some kind of observation to him. And I remember very, very well when I was Solicitor General, people were constantly pressing me to write op-eds, to make statements, to give speeches about current matters. And I thought that entirely inappropriate. If I want to reach the mind of the judges, it has to be in the context and the format that's appropriate. And that, of course, is the courtroom and the brief and public documents. Well, there's one other thing that is important, and it is so important these days, to trying to reach the judge, to reach the mind so that it isn't open. And that, of course, is our totally broken appointments process. I'm talking about federal judiciary. The state judiciary, that's another, with elective judges in various formats. That's for another talk. Well, the appointments process has become what I would call a kind of, oh boy, sorry, gone. Why have I, can you see me? Have I gone off the screen?
No, you're still on.
Okay, good. All right. Well, the appointments process has become a kind of preemptive, inappropriate interference in the mind of the judge. What has happened with the appointments process, it is so probing, it is so, well, the term is politicized which sums up something which you all know, that well, I don't know, why am I not here? I'm sorry. Pin, will that do it? Well, okay, I'm
Professor
back.
Fried, we can see you, don't worry.
Okay, good. Well, so you're not missing the best part. All right, fine. Well, the appointments process has become an evident way of so narrowing the choices that though you may never pick up the phone and do a bit of telephone justice or bar justice or whatever, BARR that is, nevertheless, you might as well not have it done. You know who you put on the bench because you combed through hundreds of resumes, former speeches, former judgments, and you know what this person will do in any given case. That is terrible. It is, as I say, an attempt at preemptive judicial interference. So what are we going to do? I ask you to think back to how we used to do this. And I am so glad to be talking to the New York City Bar about this. Because think of some of the great lawyers who became judges from New York: Cardozo, Friendly, and the man who formed my idea of what it is to be a great judge, for whom I clerked, John Marshall Harlan. All of these judges, in one way or another, surprised the men who had appointed them, in one case or another. And yet, they did not feel that they had betrayed their appointing authority, because there was no notion that there was that kind of pre-commitment. The mode of appointment was, and I hope it will return to be, not here. I am a member of the Federalist Society, and I believe I have been, maybe I still am, faculty advisor. But the process of having the Federalist Society be the filter of federal judges runs counter to this, because that is like having, books which are viewed by the Holy Office to see if there is anything heretical in them. Nihil obstat. The Federalist Society, or Mr. Leo, gives Trump his nihil obstat before he makes an appointment. Terrible, terrible. How did it used to be? It used to be that you do not take young people who can be on the bench forever, but people who are experienced. They are experienced lawyers. Every one of the men I just mentioned are that. They are known to the profession. And what are they known for? They are known for the kind of judgment, the term is judicial temperament, that they are likely to show. As practicing lawyers, for instance, The bar knows that this is a man, this is a woman who, though will be a vigorous opponent to you and your client, you can trust. You can be sure will make an appropriate argument. As a judge, a lower court judge, if we're talking about Supreme Court judges, appointments, this is a judge who parties on both sides, winners and losers, come away saying, I got heard and I got a fair shake. That is a reputation which you can only earn over years. I'm not sure that you can earn it, as a matter of fact, by years and years in a position as a law professor and as a theoretician. So that's how we used to do it. I do hope that in the not distant future, we will return to that. And with that, I will stop because I've run over my time.
Professor, thank you very much for your presentation. I'd like to remind the participants that you can use the Q&A button at the bottom of your screens to pose questions to Professor Fried. I see that there is one question already that asks the professor, you didn't get into the state court system, but on the assumption, as it operates here in New York City in particular, that a judge who runs on a particular party ticket within certain sections of the city is going to be elected based on that party affiliation. Isn't that a similar sort of influencing pre-judicial selection, what it is that that judge is likely to do on the bench?
It's very simple. Yes is the answer. The answer is yes, but it's worth thinking why it is that New York has nonetheless escaped the worst possible entailments of what that yes answer gives. I mean, after all, Cardozo was a New York judge and a great New York judge. He was probably a greater New York judge than he was a federal Supreme Court judge. Well, how did that come about? What was the real process other than the formal process you describe? There must have been some, and of course I think of Charles Breitel, I think of Stanley Fuld, and many, many others. What was the constraint on what is potentially an extremely corrupting, and I use that word carefully, corrupting process? There must have been some constraint. And I think it is the constraint that that vice pays to virtue, to misuse an aphorism of Rochefoucauld. The political system in New York is as vicious, but no more vicious than any other. And yet that vice pays to virtue the periodic choice of really excellent people, because there is this respect for the robe, this respect for what is in fact nothing but a secular clergy. Does that help?
Yes, Professor. Professor, you indicated that there is a desire to return to the appointment of or the nomination of more experienced judges. In the past, presidents have nominated trusted friends or senators and other non-judges for positions on the Supreme Court. Do you consider that a practice that should be reconsidered?
It is very risky. Sometimes the risk pays off. Earl Warren. Now, he was a lawyer, at least that. He had been Attorney General of California. He actually had been Attorney General in part during the playing out of the Japanese internment, and he was not averse to that. He was chosen in part for political reasons. And there's a whole long story. We got lucky. Hugo Black, similarly, was a wonderful judge, and in fact, an extremely austere judge. It was my privilege to be a law clerk in the next chambers to Hugo Black's. And my Justice, Harlan, revered Hugo Black exactly because of his austerity, the purity of his devotion to the office. Hugo Black would never vote in an election because he thought that was, in a sense, corrupting. So sometimes you get lucky. Sometimes you don't. Harry Truman made a number of appointments which didn't turn out so well. As I remember, among other things, I think Jackson, who had his chambers, I think it was next to Minton, said bordering on incompetence was his way of, particularly Jackson way of putting things. And Jackson himself, great judge, great New York lawyer. So sometimes you get lucky. Maybe you get lucky because the appointing authority has that respect, which I spoke of. Lucky us when that happens.
Professor, we are actually beginning to come close to the time for your presentation, but I have one last question for you from our participants. What is your view on the expansion of seats on the Supreme Court?
Oh, the question which Kamala Harris wouldn't answer last night.
Correct.
I do have a view on that.
Please share it.
First of all, if you have a historian's eye, it is not unheard of. In fact, Congress has played around with the expansion and contraction of the court a great deal over the years. The last time, however, that this was an issue was, of course, in 1937, when, what was the year? Was it 35? That Roosevelt proposed expanding the court to 15. That would not have been an unconstitutional action, nor would it have been unprecedented. Remember under what circumstances he took it. He proposed this towards the end of his first term, when the old Supreme Court had consistently knocked down the actions Carter Cole, Schechter Poultry, Butler, over and over and over again, knocking down the heart of the New Deal. So he thought something drastic was necessary. we will have a court with, I suspect, because the McConnell and Trump, Humpty Dumpty, are absolutely determined to have it so, and I don't see what will stop them, not even the virus, to have a court with 3 Trump-appointed judges. Well, that requires that drastic remedy only if, in experience, it is intolerable. But it's quite possible that putting on the robe will have an effect on who those judges are. Judge Barrett already wears the robe, and she is an honorable person. It's quite possible that that she, though may have not an empty mind at all, because she's a very able woman, but she may have an open mind. Look at the way Chief Justice Roberts has evolved. It's only if we reach a desperate situation that would be appropriate. So if I'd been Kamala Harris, that's what I would have answered.
Professor, thank you very much for your time. I am sorry that we won't be able to ask additional questions of you now or later, but on behalf of the City Bar Association, we very much appreciate your participation in this program.
Thank you.
We now turn to our next speaker, who is Chuck Rosenberg, who will provide a prosecutor's perspective on today's discussion. Mr. Rosenberg served as the administrator of the Drug Enforcement Administration from his appointment in May 2015 until his resignation in October 2017. Prior to that, Mr. Rosenberg served as Chief of Staff and Senior Counselor to the then FBI Director. He also served as U.S. Attorney for the Eastern District of Virginia and for the Southern District of Texas, and as Chief of Staff to Deputy Attorney General James Comey, and Counselor to the Attorney General John Ashcroft, and Counsel to the FBI Director Robert Miller. Mr. Rosenberg, the floor is yours.
Oh, thanks, Roger, and thanks for inviting me to this. It's a real honor. I got to tell you, I'm feeling mighty insignificant to be speaking between Professor Freed and Judge Rakoff. For those of you who are baseball fans, it's like Mario Mendoza hitting after Tony Gwynn and before Roger Carew. If you're not a baseball fan, there's something to Google if I bore you while I'm speaking. Roger, I went to law school only because I wanted to be a federal prosecutor. It's the only thing I wanted to do. I was incredibly fortunate to go to the University of Virginia for law school and to join the Department of Justice afterwards. I love the Department of Justice. I love its mission. I love its history. I love its people. And I should say, I am very deeply concerned about what I see there now, and a very different type of interference than what Professor Freed was just describing. This interference, I think, is predicated on not just bad leadership, but venal leadership, and leadership that sort of fundamentally misunderstands what it is the Department of Justice is supposed to be and how they're supposed to do their work. I don't intend to take a very long time here. I want to speak briefly. It's an Eastern District of Virginia thing, and then shut up, which I've always found to be a pretty good tactic in court. The Department of Justice is governed, of course, by statute and rules and regulations and policy, but I think a lot more than people appreciate, it's governed by norms. Those are the things between the lines, right? Not how we are directed to behave, but how we learn to behave, the ethos of the particular offices in which we work. And I also want to stress there are sort of two sides to this coin I'm going to describe for you. The need to be fair and the need to appear to be fair, right? So being fair without appearing to be fair is good, I guess, because you want to be fair, you want to be objectively fair. But if there isn't that sort of public buy-in in the mission of the department and a belief that we are actually being fair, obviously dangerous. And appearing to be fair without actually being fair is even worse. If you lose that objective fairness. Historically at least, the Attorney General of the United States has a difficult role, a dual role, both a political role and an apolitical role. And I know attorneys general, and I've worked under probably a dozen of them from both parties, never caring, frankly, who they were or what party they came from, have a really difficult line to walk. So in the political role, an attorney general is a member of the president's cabinet, obviously, and there are clearly political things that an attorney general can do and should do. For instance, proposing legislation or lobbying for legislation on the Hill, pushing the president's enforcement priorities through the Department of Justice. Even in the selection of judges, there is an appropriate political role for an attorney general. Mindful of what Professor Fried said, but nevertheless, I think that role in helping the president decide who ought to be on our federal courts is an appropriate political role. There's also a place where an attorney general ought never stray. And this is the apolitical part of the job, right? And it's into the criminal enforcement mechanisms of our work. Now, I understand that the attorney general is vested with the full authority of the Department of Justice, and he or she delegates it to us. I was a U.S. attorney. I was an AUSA for many years. I don't mean to suggest that the attorney general has no say, just that the political influences, the political considerations can never infect the criminal enforcement work of the department. And this is a place where a president has to stay very, very far away. So clearly an appropriate political role for an attorney general in some regards, and a place where the president and the attorney general have to stay completely out of criminal enforcement work, at least with respect to political influences and political considerations. So, for instance, Professor Fried mentioned the Flynn case. The attorney general siding with the defendant, finding that Flynn's lies were not material, which is a travesty. Of course they were material, it's not even a close call, and intervening to ask that the judge, Judge Sullivan in this case, dismiss the case. I think it's ludicrous. That's my 2 cents. But it was also predicated, obviously, on the president's statements and tweets about what ought to happen to Michael Flynn. A very, very dangerous place for the Department of Justice to go, and a very, very dangerous thing for an attorney general to permit a president to infect the process. Remember, we have to both be fair and we have to appear to be fair. Same with Roger Stone, the attorney general intervening in the sentencing of Roger Stone. Now, he may have felt that the sentencing guidelines in Mr. Stone's case were unjust, too harsh. If that's true, it's probably true for lots of defendants around the country for whom the attorney general remained absolutely silent and never intervened. Again, seems to be predicated on things that the president has said and the president has tweeted. We need to be fair, and we need to be to appear to be fair. I also think the attorney general's characterization of the Mueller report was deeply unfair and wildly inaccurate. I think I'm one of 7 Americans who actually read the damn thing. It's 448 pages. I would urge you to do that too if you haven't had the chance. But the notion that the president was exonerated, completely belied by the facts, particularly in volume 2 of the Mueller report, which lays out a series of obstructive behavior by the president, for which I think almost anybody else would be indicted, convicted, and incarcerated. And so we have now, I think, executive interference, both from the president and the attorney general of the United States, in the criminal enforcement mechanisms of the department, which absolutely, I think, are sacrosanct and are in, and I don't want to overstate this because I'm not typically given to hyperbole, but are in grave danger. Let me just say a few words about election year sensitivities. That's the name of a memorandum that's issued quadrennially by the Department of Justice. I remember seeing it from Mukasey. I remember seeing it from Holder. I remember seeing it from Lynch, prior attorneys general, Republican and Democrat appointed. The notion being that in an election year, the Department of Justice cannot, should never take overt investigative steps to influence, with the purpose of or intent of influencing the outcome of an election, or advantaging or disadvantaging any candidate for office. Sometimes people think of it or refer to it as a 60-day rule or a 90-day rule. I always thought of it as something that kicked in after Labor Day of an election year. There actually is no number in the policy itself, but whatever that sort of the cutoff ought to be, there's two things I want to say about that policy, about that rule, about that norm that are important. One is, as prosecutors, we know what the policy says, right? But we also know what it means, which are two different things. What it means sort of takes me back to that thing I said earlier about norms. How you behave is what's between the lines of your policies and your rules and your regulations. And so the norm, of course, was whether it was 60 days or 90 days or just before Labor Day or just after Labor Day, you knew as a federal prosecutor, you know as a special agent of the FBI, to stay the hell away from elections, because it's so dangerous for the criminal enforcement work of the Department of Justice to appear to be anything but fair. So the policy itself, I think, is arguably ambiguous. What is an overt investigative step? I mean, we're not allowed to take them, but what is it, right? For instance, is issuing a grand jury subpoena an overt investigative step? Now, under Rule 6C of the Federal Rules of Criminal Procedure, as a federal prosecutor, I'm not allowed to talk about what happens before a grand jury. My agents aren't allowed to talk about what happens before a grand jury. So from my perspective, perhaps I could argue that issuing a grand jury subpoena is not an overt investigative step. Of course, Rule 6C doesn't bind recipients of grand jury subpoenas. They're more than free to talk about it. And so perhaps it is an overt investigative step. It's not clear, right? The policy is somewhat ambiguous. And by the way, what does it mean to influence an election? I want to give you a really, really interesting example, at least what I think is a really interesting example, out of New York. So in 2011, and by the way, I'm stealing this from Preet Bharara. It's something he writes about in his book, Doing Justice, and he and I talked about it on my podcast, but I think it's a fascinating example. In 2011, the Bronx District Attorney had a corruption case against a sitting member of the New York State Assembly named Nelson Castro. And they weren't making enough headway, or at least not fast enough headway with the case. And so the DA in the Bronx called Preet, who was then the US Attorney in the Southern District of New York, and asked to partner on the case. And they did. And with the resources of the Southern District and the FBI, the case moved more quickly. In fact, Castro, the sitting assemblyman, who was up for election in 2012, agreed to wear a wire because there were other members of the assembly and other sort of shady businessmen who the FBI and the US Attorney and the Bronx DA thought they might be able to catch in the act. So here's the dilemma. The Southern District of New York knew Castro was up for election. They knew he was corrupt. They knew he was cooperating. They knew he was going to ultimately plead guilty. They knew he was going to resign from office, but the case wasn't over. In fact, it would have to extend beyond the election. Do you let him run for re-election? Is that a fraud on his constituents? Is that unfair to his opponent who wasn't corrupt? Is it unfair to New York writ large, or to other members of the assembly, to allow somebody who is corrupt and who will have to resign to stand for election? Well, tough call. The ethos of the department, remember, we have to be fair and we have to appear to be fair. Sometimes it's a really, really difficult decision. They wrestled with it in the Southern District of New York. They ultimately decided to allow Castro to remain in office. In other words, not to take a guilty plea before the election. He ended up cooperating against another member of the assembly, a guy named Eric Stevenson. The Southern District of New York ended up with more convictions as a result. Castro and Stevenson ultimately resigned. It may have violated the election year policy. So I don't mean to suggest that these things are always easy, but I do want to tell you it's something that we wrestle with and that we think about a lot. And here's what I'm leading to. If you're wondering whether or not I actually have a point, I do. It's this. We've heard a lot of talk about John Durham, who I respect and who I like and who I admire, the US Attorney in Connecticut, who the Attorney General has asked to do yet another investigation of Russian interference in the 2016 election, more specifically, how the FBI began its investigation and how they conducted that investigation. I know John and I like John. I'm not worried about John. I'm actually worried about what the Attorney General is going to do with John's report. That's what deeply concerns me. Is releasing a report in the run-up to an election violative of our longstanding policy not to interfere? Well, it's not an overt investigative step, arguably. You could also argue that it's not intended to advantage or disadvantage anybody who's running. I mean, you could argue that, I think, sort of both ways, but it isn't an indictment of Biden or an indictment of Trump or an indictment of Harris or an indictment of Pence, right? It's sort of a step removed from that. But if that's the case, why would Mr. Barr be anxious to have the report out before the election? And ought we be concerned about that? And so, these are hard things. Given Barr's track record on Flynn and Stone and on the Mueller report, I am worried. I think this is a hard thing to fix. I don't know that you fix it by issuing new policy or by passing new legislation. Again, because so much of what we do is between those lines, right? Again, those norms are not necessarily in writing. The way you fix this thing is by hiring people who know, love, and respect the Department of Justice and who abide by its norms, who abide by the ethos that we are learned, that we sort of taught as young federal prosecutors to embrace. I'm worried about the Department of Justice. I am also an optimist. I know that may sound contradictory, but I think we are in a very, very difficult set of circumstances with both the president and an attorney general who do not abide the norms of the department, who are not carefully delineating the work of the attorney general between the appropriate political chores that he has and the criminal enforcement mechanisms that have to remain outside of the purview of politics. So, Roger, that's all I got right now. I told you I'm an Eastern District of Virginia guy, so we're told to say what we have to say and then shut up, so I'm done.
Mr. Rosenberg, you may be aware that the City Bar Association's Task Force on the Rule of Law, chaired by Stephen Cass, has issued a series of public reports critical of the Attorney General. And in those reports, made reference to the statements made by the Attorney General when he was being nominated for the position that echo many of the norms that you have set forth in your presentation that that should drive the role of the Attorney General. And this is the opposite of the issue that Professor Fried raised. Here you have someone who goes through a nomination process articulating those norms that we respect, and then, as you've indicated in your presentation, departs from those norms in practice. How do we deal with that going forward? What would you recommend be part of the inquiry process into the next Attorney General?
Yeah, it's a great question. I mean, look, I have my own list of people who I'd like to see in that job, people I know and respect and trust. I'll also tell you, Roger, I was one of those fools on television, those quote unquote analysts who welcomed Bill Barr back to the Department of Justice because I thought that Jeff Sessions was a disaster, that Barr had been at the department previously and was a principled institutionalist. I never thought I would say this, but I miss Jeff Sessions. Of course, that's only relative. So, those of us who know and love the department also got it wrong. I mean, a lot of my fellow alum got it wrong. We thought that Barr was somebody who respected it. Professor Fried made this point earlier, and I think he's right. Sometimes people surprise you, and sometimes they surprise you in the right direction, and sometimes they surprise you in the wrong direction. But the more I think about it, having people who've grown up in the Department of Justice system, who've been career AUSAs, who've struggled, who've made mistakes, who've had to fix them in open court, who've tried cases, right? I think are the ones who are probably best suited to lead the Department of Justice. I thought Bill Barr was, for lack of a better term, Roger, one of us, but he really wasn't. Right? He was a political. He was briefly at the department. He was the deputy attorney general. He was the attorney general. I think he was in office of legal counsel, if I'm not mistaken, for a time. And that was it. He didn't really come up organically through the system. And so I don't know that there's a set of questions that will, that will satisfy us. I don't know that there's a resume that will satisfy us. It's almost like Potter Stewart. I know it when I see it. You know, I see it in people like Sally Yates. I have my fingers crossed that, you know, we have someone like Sally running our beloved department. I don't think I would be disappointed, but I don't know that I have a prescription for you.
Mr. Rosenberg, other than participating in forums such as this, do you have any recommendations for bar associations such as ours as to what to do to try and stem the deterioration in the rule of law and the politicization of the judiciary and the Department of Justice?
Yeah, that's a great question. So one of the things I worry about the most, I also teach at Georgetown at the School of Foreign Service, so not at the law school, but undergrads. I teach a national security law and policy class. And these young men and women are super smart and they're super engaged, and it's an incredible privilege to teach at Georgetown. I was not smart enough to get into a school like that, but I love teaching there. And the thing they ask me semester after semester is it okay to go into public service, right? And, you know, these are young men and women who are thinking about foreign service or the intelligence community or federal law enforcement. And it's a heartbreaking question, actually, because it's not a question that I remember hearing, you know, 10 years ago or 20 years ago. It's a question I've heard in the last 3 or 4 years repeatedly. And so I hope the Bar Association is doing everything it can to talk to the folks who are going to take care of us when we are, you know, older, who are going to take care of our institutions. I really worry about that, because if we're not getting these smart men and women from Georgetown and other schools like it to do those types of things, we're lost, right? Where is that going to come from? Where is that institutional knowledge and history and ethos and love for these things that we hold dear going to come from? So I would urge you, I don't know, I'm sure you're doing it already, but I would really urge you to reach out in as many ways as you can to kids, not just college and law school, that may even be too late, but to kids in middle school and high school, and show them what it means to serve in our government and how important it is and how much we need them.
Mr. Rosenberg, for the last question, I'm going to ask you to sort of deal with a reverse spin. Mm-hmm. There are some critics of our current system, and in particular, the prosecutorial function, saying that it is turned into a creature of its own, a so-called deep state, and that it's not responsive to the democratic process of electing, as expressed through elections. How would you recommend that the next Attorney General deal with the tension of being responsive to the will of the electorate while at the same time adhering to the norms that you've described?
Yeah. That's a great question. It's a hard question too. I mean, keep in mind that the federal law enforcement system is a tiny, tiny fraction of the criminal justice system in the United States, right? So we have, for instance, 18,000, so it's a staggering number. We have 18,000 law enforcement agencies in the US. I'm guessing that 60 or 70 are federal. Ask somebody, or I'll ask you, Roger, I don't mean to put you on the spot, but do you know how many special agents there are in the FBI?
I do not.
About 13,000 and change, which makes them 1/3 the size of the New York City Police Department, okay? New York City Police Department has 37, 38,000 uniformed officers. FBI has about 13,000 and change special agents. So I think so I'm not trying to shift responsibility, but I think the bulk of the problem is not in the federal law enforcement system, just because we are so tiny in comparison. The other thing I worry a lot about in terms of responsiveness, so, you know, we have a lot of things we have to get right, including 18,000 other law enforcement agencies in the US, from very, very big, sophisticated ones, well-resourced, like the New York City Police Department, to very small ones that are under-resourced and frankly terribly unsophisticated. And when you think about justice as a citizen, you're probably not thinking about the FBI or the DEA. You're probably thinking about a traffic ticket you got, you know, rolling through a stop sign in your hometown. And so when people are thinking about criminal justice, that's where I think we have to focus. And that's where just in terms of sheer numbers, Roger, where the majority of the problems are. And so, you know, can an attorney general fix that sort of system? honestly, realistically, I don't think so. I think that's governors and mayors and city council members and folks like that in communities around the country that have to focus on what's going on locally. We have 14,000 school districts in the United States. I mean, the notion that the Department of Education at the federal level can fix 14,000 school districts is insane, assuming 14,000 needed fixing. Some do and some don't. But by the same token, the notion that the Attorney General in the United States Department of Justice can write 18,000 law enforcement agencies in the US is equally insane. And so I think this is really, we got to set the tone. Maybe we have some grant money. Maybe we have best practices, right? There's a bunch of things we can do, but I don't think the fix for the criminal justice system writ large comes from the Attorney General of the United States.
Mr. Rosenberg, thank you very much. Fortunately, Mr. Rosenberg will be available for additional questions at the end of the program. So I will now turn to our next speaker. I am pleased to introduce the Honorable Jed S. Rakoff, who will provide us a judicial perspective on today's proceedings. Judge Rakoff has served since 1996 as a U.S. District Judge for the Southern District of New York. He is an adjunct professor at both Columbia Law School and NYU School of Law. Judge Rakoff also teaches at Berkeley Law School and at the University of Virginia Law School. From 1973 through 1980, Judge Rakoff served as an assistant United States attorney in the Southern District of New York. During the last 2 years there as chief of business and securities fraud prosecutions. From 1980 through 1985, Judge Rakoff was a litigation partner at 2 large law firms in New York. Judge Rakoff, please proceed.
Thank you so much, Roger, and it's a great privilege to be part of this very distinguished panel. But I need to say at the outset that under federal law, I am precluded from commenting on any pending case, not just before me, but before any judge. And I'm also precluded from commenting on any issue that's liable to come before me for decision in the immediate future. So that really concludes my remarks. It's been very nice.
Nice try.
Maybe not. I want to discuss a topic that is indirectly related to the overall focus of this panel, which is why the federal courts, in my opinion, have been far too deferential to unilateral acts of the executive branch. And I'm going to suggest that this has a long history, that it is prompted by judicial fears of retaliation from the executive branch, and that maybe that's not a appropriate way to look at it. So I want to start with a case you may have vaguely heard of called Marbury versus Madison. And many of you will recall that after the Jeffersonians swept the election of November 1800, the Federalists, who still at that point had a few months in office, appointed a bunch of judges to the federal courts, including Chief Justice Marshall, and also created a bunch of new judges, the so-called midnight judges. Among the judges they created were some fairly low-level judges called justices of the peace, sort of vaguely similar to the magistrate judges of today. And the way at that time a judge became officially a judge was that after the Senate had confirmed the nomination, the president signed the commission, the Secretary of State signed the commission, and then affixed the seal of the United States, and then it was delivered to the judge. Well, the Secretary of State at that time was John Marshall. And he got around to doing this for most of the judges, including his brother, who became a circuit judge. But while he signed the commissions for the justices of the peace, he left them on his desk when he left, and they were discovered the next morning. Jefferson, who had already denounced this occupying of the judiciary by the people who had lost the election, said that he was ordering his Secretary of State, not who eventually became James Madison, not to deliver those commissions, and those people would not be considered judges. Well, one of them, Mr. Marbury, then brought an action in the Supreme Court, and Jefferson announced in advance that if the Supreme Court ordered him to deliver the commission to Marbury, he would not do it. He would not carry out that order. So against that background, there was a sort of evidentiary hearing before John Marshall, who was by that time Chief Justice. Conflicts of interest were not too strong in those days. One of the main witnesses at that evidentiary hearing was John Marshall's brother. But in any event, the hearing took place, and then Marshall issued his famous opinion. And of course, it's famous because he pronounces that it's emphatically the role of the courts to decide what the law is. And he also goes on at some great length about how Mr. Marbury has been totally wronged, and everything was in place. He should have been a judge and all like that. But then his bottom line is to say that, well, the statute which gave the Supreme Court the right to issue mandamus at the trial level was unconstitutional, and the Supreme Court did not have that power. And therefore, too bad, Mr. Marbury, you lose. And I think one can look at this as a capitulation to the threat from Jefferson. It's often viewed as a great Solomonic compromise in the early days of the court. But let's take a look at another case about 28 years later. This is the case of Cherokee Nation versus Georgia. And the Cherokee Nation had signed a treaty with the United States that gave them lands in Georgia that they occupied. Then it turned out that those were pretty valuable lands. So the state of Georgia said, we're going to take those lands for ourselves. So the Cherokee Nation then brought action in the Supreme Court. There was clear jurisdiction because they were a sovereign. And the Supreme Court, again, per John Marshall, in one of his last opinions, begins by saying I should interrupt for 1 second. Andrew Jackson had announced, after this case was argued in the Supreme Court, that if the Supreme Court ruled that he had to give the land back to the Indians, he would not enforce it. Jackson said this actually several times on several cases, reflecting, to be frank, his very clearly racist views. But in any event, in the opinion that came down from Chief Justice Marshall, Marshall begins by saying that we're extraordinarily sympathetic to the Cherokee. They're getting badly treated in this situation. The treaty was explicit that it was their lands. But what's his bottom line? His bottom line is, well, they're not really a full sovereign. They are wards of the executive, of the federal executive. He even goes so far as to say, and that's why they call the president the Great White Father. So it's only up to the executive to counter what the state of Georgia is doing here, and they have chosen not to. And so be it. We can't do anything here on the Supreme Court. Once again, in my view, a total capitulation to a threat from the President of the United States. Well, on the basis of cases like that and many others, there developed over the next century a long list of areas in which the Supreme Court and the federal courts have said, we won't touch this particular area of executive operation, or we won't touch that area of executive operation. The most defensible, obviously, is the war powers. But even there, the Supreme Court has taken it to ridiculous lengths. And the classic case, which Professor Fried already alluded to, is the Korematsu case in the 1940s, written, by the way, by no less than Hugo Black. In Korematsu, the Supreme Court said that because a general down in the Pentagon has made the determination approved by the president that Japanese Americans are a threat to our national security, we're going to take all these American citizens and put them in our own concentration camps while the war is going on. I mean, yuck. I mean, so you can see how the war powers doctrine was extended hugely, because the Supreme Court, in the decision by Black, said, "Oh, that's just an exercise of the war powers. We can't touch that. That's totally in the hands of the president." Another area where the Supreme Court has given an incredibly broad application is in foreign affairs. Again, you can understand that in a narrower sense, but I'll give you an example from a case I had. The India mission to the UN owns a 26-story building in Manhattan, and they rent out large portions of that building, mostly to people who work in the mission or have some association with the mission. And the city of New York brought an action saying that they were entitled to real estate taxes on those portions of the building that were not being used for the business of the mission itself. Good arguments on both sides of that question. It could have gone either way. It came before me. I decided in favor of the city. It goes up to the Second Circuit. And then, and only then, does the Department of State send a letter to the Second Circuit, and they say, don't touch this. We have decided in the exercise of our foreign affairs powers that the city cannot tax the Indian mission in any respect whatsoever. We've also decided that that should be applied retroactively. And so get lost. And the Second Circuit said, you're right, boss. We can't touch this. It's foreign affairs. And on the basis of that belated letter from the Department of State, they reversed the case. I won't go through a lot of cases, but other obvious examples of this are sovereign immunity and qualified immunity, which figure so much in recent debates about police practices and the like. Sovereign immunity ultimately rests on the common law notion that the king can do no wrong. Now, I had the illusion that we fought a revolution back in 1776 because we thought the king could do plenty wrong. But silly me. Sovereign immunity and qualified immunity are still very much alive in the federal law of the United States. Then there's the question that bedevils every law student: standing. There are so many definitions of standing. It's not, according to the Supreme Court, just based on Article 3 case and controversy limitations. It is also based, as many Supreme Court cases have said, on prudential limitations on the court's role. In other words, even though under the Constitution we could decide whether that particular executive action was wrong when someone brings in a lawsuit against it, in many cases we will decline to hear it, invoking that prudential notion of standing. And then finally, and this is just, I could go on at great length with many examples, but there's the political question doctrine. What is the political question doctrine? Well, here's how it is defined by the Supreme Court in Baker v. Carr. Quote, prominent on the surface of any case held to involve a political question is found a textually demonstrable constitutional commitment of the issue to a coordinate political department, or a lack of judicially discoverable and manageable standards for resolving it, or the impossibility of deciding without an initial policy determination of a kind clearly for non-judicial discretion, or the impossibility of a court's undertaking independent resolution without expressing lack of the respect due coordinate branches of government, or an unusual need for unquestioning adherence to a political decision already made, or the potentiality of embarrassment from multifarious pronouncements by various departments on one question, close quote. Got that, fellas? If you know what that means, you're doing a lot better than me. But what it clearly means is that doctrine is sufficiently broad and sufficiently vague that when the court wants to invoke it, like in many gerrymandering cases, they can. So what is prompting this extreme deference to the executive, to the unilateral actions of the executive, going far beyond anything that the Constitution authorizes or demands? My own view is it's prompted by the fear that the executive will interfere with the judiciary. And that the hope is that by being so restrained in terms of the executive will reciprocate and be restrained towards the judiciary. I think that is not borne out by history. We just heard from two speakers on preemptive interference in the appointment of judges. I already mentioned the actions of Jackson and Jefferson, but one can think of Abraham Lincoln's canceling the writ of habeas corpus in clear violation of the Constitution, and the Korematsu is another example of more recent vintage. Some presidents are going to do this, some presidents are not going to do it. Some are going to try to control the judiciary, some are not. It does not, in my view, correlate with the judiciary defaulting on its constitutional obligation, in my view, to scrutinize the actions of the executive just as you would scrutinize the actions of anyone else. So I will conclude on that note.
Thank you, Your Honor. Based on my personal experience having appeared before Judge Rakoff, I'm loath to pose a question to the judge, given what the consequences might be. So I'm going to call on the fellow speakers of Judge Rakoff to see if any of them have a question for the judge. Harold, Professor Coe? You need to unmute, Professor Coe. Go ahead,
Yeah.
Professor Coe, go ahead.
So Judge Rakoff, I appreciate your presentation. I actually teach all the cases that you mentioned, and many of them we don't teach the exact same way. You know, Marbury versus Madison, we generally teach as a case where the court knew that his order, Marshall's order ordering the commission to be delivered, wouldn't be accepted at that time because the court was so weak. So what they did, essentially, John Marshall, in what is usually viewed as a very clever move, said he was required to not do anything because he was claiming the much greater power of judicial review to strike down a statute as unconstitutional. So it's a very clever, unreviewable power grab, which has led courts to have much more oversight than they were able to do before. You gave
So
me,
that,
let me go through the other cases.
yeah,
I think,
go ahead.
Korematsu has been overruled last in the travel ban case.
Yeah, how many years did that take?
Well, it was overruled, I think, in the court of public opinion long before and hasn't been cited. I think the permanent mission of India case is about the executive branch carrying forward obligations it has under international treaties to assert immunities so that similar kinds of immunities are respected in other countries. And finally, the political question doctrine, which you read, has been dramatically narrowed in foreign affairs a few years ago in Zivotofsky versus Kerry, where John Roberts essentially shrunk it from the 6 factors you mentioned to 2 factors. So I think that, while I take your point, a judge who's not interested in totally caving to the executive has plenty of avenues by which to use the existing precedent, most particularly the steel seizure case, Youngstown Sheet and Tube, to essentially say that president's conduct of foreign affairs or other kinds of activities is subject to judicial review and even invalidation.
So, of course, Professor Coe is a great law professor and a former member of the federal executive branch, has posed some good questions there. I think, to be frank, you're missing the woods for the trees. I think if it is hard to see the history of federal law in this country as being other than deferential to a great many areas of unilateral executive action. And the fact that Korematsu was ultimately overruled, you know, what good was that when all those people throughout World War II were stuck in a internment camp? It did them no good, and in overruling it, as you say, the court was reacting to current public opinion, but I'm sure that wasn't the public opinion in 1942 and 1943. With respect to Marbury, yes, Marbury is classically regarded as a very clever move by a very clever Chief Justice, and I think that's a fair point. I'm just pointing out that it also set the precedent for a lot of capitulation, and it's one thing when the judiciary is very weak, as in 1803 when Marbury was decided, and something totally different in 1832 when Chief Justice Marshall decided the Cherokee case. The only thing that was common to those 2 situations was the president had already announced in each case, I don't care what you decide, I'm not going to enforce it. And Marshall decided not to take him on. even though I think the law clearly required him to take him on if he had been deciding those cases down the middle on the basis of the law, particularly in the Cherokee case. But you know, when I was in law school, I was always intimidated by the law professors, and I still am.
Your Honor, an anonymous questioner asks whether you consider it appropriate for a very recently appointed judge called upon to rule on an issue that has enormous impact on the person who nominated him or her, whether under such circumstances the judge should recuse him or herself. And
So,
please describe
yeah.
why or why not.
First of all, I do not know a single judge who, within a year of going on the bench, state or federal, has not decided a case contrary to how, if they were just a citizen, they would decide the case, because that's what the rule of law means, that you can't elevate your own preferences above what the precedent and the statutes and the rule of law demand. This is going to sound a little corny, but it's true. Whenever I put on the robe, to me, it changes my thought processes. I feel, okay, I'm no longer Jed Rakoff, the talkative Yankees fan. Now I have to be someone who is blindly applying in a neutral way the law. And I do think that the very great majority of judges feel that way. Does that mean they won't be unconsciously affected by their predispositions? Of course, no human being can totally escape that. But I think even very new judges prove their independence by making rulings that they never would have made if they were making the political decision, so to speak.
Your Honor, thank you very much for your time and your thoughtful comments. I'm sorry that we can't pose additional questions to you now or later, but again, on behalf of the City Bar, thank you for your participation today.
Well, it's a pleasure, and I'm happy to escape before Harold Coe puts another question to me.
So as it turns out, our next speaker is Harold Hongju Coe, who is a Sterling Professor of International Law and former Dean at Yale Law School, where he has taught since 1985. Professor Coe is a former law clerk to Justice Harry Blackmun and Judge Malcolm Wilkie of the DC Circuit, and served as the legal advisor of the United States Department of State in the Obama administration. He also served as Assistant Secretary of State for Democracy, Human Rights, and Labor in the Clinton administration, and as the Attorney Advisor to the Department of Justice Office of Legal Counsel in the Reagan administration. Professor Coe, please proceed.
Thank you, Roger, and thank you, Steve, for inviting me. It's a great honor to be here, particularly with my good friend Margie Love and also Judge Rakoff, who I greatly admire as well. Let me use my Mike Pence opportunity to say 30 seconds. I actually think that Judge Rakoff obviously points to a danger, which is over deference, but I think the greater danger we're facing from judges are that they are insufficiently deferential to precedents by using their power of judicial review to engage in judicial activism. The greatest threat we have right now is that a new justice will come in and strike down the Affordable Care Act and hold the entire law to be inseverable, and thereby bring down something which has been upheld against constitutional challenge more than 10 years ago. I think also there's a great danger that despite the fact that the Supreme Court upheld Roe versus Wade on stare decisis grounds in Planned Parenthood versus Casey, that justices who are insufficiently respectful of that precedent will reconsider a case which is now nearly 50 years old. But anyway, that's another story. I'm here for a more limited purpose, which is to discuss the issue of the president's legal authority to interfere with state and local law enforcement. And this is an issue that arose on June 1st of this year in what became known as the Lafayette Square incident. I want to distinguish the Lafayette Square incident from the Lafayette Square claim. On that day, as you recall, President Trump made a speech in the Rose Garden where he said he could deploy US troops to American cities over the objections of city and state leaders without a court order. And he said, quote, "If a city or state refuses to take the actions necessary to defend the life and property of their residents, I will deploy US military to quickly solve the problem for them." And then he talked about dominating the streets. Now, what we learned from reporting from the New York Times was that he originally planned to invoke something called the Insurrection Act and then decided not to because of advice from some senior officials. His press secretary mentioned that he could have invoked the Insurrection Act. Senator Tom Cotton, in a op-ed in the New York Times, said he should use the Insurrection Act. But interestingly, the next day, the Secretary of Defense, Mark Esper, said, using active duty forces in a law enforcement role should be done only in the last resort, and we're not in that situation now. So the president's claim is much broader than what he actually did at Lafayette Square. He never actually deployed troops domestically, nor did he actually invoke the Insurrection Act. But I think what was most disturbing to me was that a number of legal experts argued that Trump either had the legal authority to commit troops under the Insurrection Act to the streets, or said that if he did so, courts would enforce it under some kind of deference principle of the kind that Judge Rakoff just mentioned. So what I want to do in my time is just make it clear. Whatever you hear from Donald Trump or anybody else, there's no exception that authorizes the president to use federal troops in American city streets on the grounds that he's stopping widespread public disorder. That is Trump's claim. Legally, it's false. He does not have that power. So let me start with the constitutional background, which is important to mention. Obviously, there's a constitutional norm that separates military from civilian space, and it bars the use of international troops in domestic settings. And it's also a general constitutional norm against using uniformed military forces for domestic law enforcement purposes. This constitutional norm is set forth in the statutory provision known as the Posse Comitatus Act of 1878, 18 U.S. Code 1385, which explicitly restricts the use of the military for domestic law enforcement purposes. And there are other statutes which very specifically bar the use of federal troops near election and voting places on election day. So if this is so clear, why are people making this claim? And the short answer is because of this statutory provision known as the Insurrection Act, which is very broadly worded. So what I'd like to do is just clarify that that's not what the Insurrection Act says. The Insurrection Act, which is at 10 U.S. Code section 251 to 54, outlines conditions where the president can deploy military forces to address domestic civil unrest. And for our purposes, there are three important provisions. First, the president can deploy troops when they are requested by a state legislature or governor. And the example of that is when President Johnson deployed troops to Michigan in 1967 at the request of Governor George Romney, Mitt Romney's father, or most recently in 1992 when President George H.W. Bush sent troops to LA at the request of California Governor Pete Wilson after the riots following Rodney King. These were not examples of presidents overriding state governors. It was an example of responding to state requests. The second provision of the Insurrection Act, Section 252, says that the president can deploy troops to American cities if there is an insurrection against the federal government that impairs the functioning of the federal judiciary. And this was passed in 1861 to give President Lincoln the authority to use military force against the Confederacy in the South, because there was both direct resistance to the government in Washington, and it was impossible to enforce US law by ordinary judicial proceedings. Now, obviously, President Trump's actions on June 1st of this year don't fit this Insurrection Act provision either. The protests that he was worried about in Washington weren't against the authority of the federal government, and they didn't make the functioning of the courts impracticable. So they were clearly not properly invoked. The third possibility is Section 253 of the Insurrection Act, which says that federal troops can be committed when a state government is facilitating the denial of equal protection of the laws to a class of citizens, and federal courts are unable to effectively adjudicate equal protection claims during that period. This was, to those of us of a certain age, most famously done in Little Rock by President Eisenhower in 1957, where President Eisenhower enforced a court order that the governor of Arkansas, Orville Faubus, had opposed. The same happened when President Kennedy sent troops to desegregate the University of Mississippi in 1962. But again, President Trump's proposed use of the military at Lafayette Square does not fit these requirements, because the protests did not cause any state to deny equal protection of the laws to its citizens, nor was there a forcible resistance that was impairing the functioning of the federal courts. Now, since then, President Trump has gone on to suggest that when there is public disorder or protests, like in Portland or Kenosha, that he can commit federal troops. In fact, there was an effort to do this in 2006 by Congress, and it was repealed in 2008. None other than Senator Kit Bond, who's no great radical, said this repeal was necessary because the public order exception that had been passed was ill-conceived, unnecessary, and dumb. Finally, I think that there are two historical examples that really demonstrate where the law really sits, executive practice. And these are two occasions where the Kennedy administration considered invoking the Insurrection Act to deploy troops to the streets, but decided that it lacked the authority under law to do so. The first was in 1963, when John F. Kennedy decided not to deploy troops to Birmingham, Alabama. And there, he said, there was an absence of violations of federal civil rights, and other cases, he had said, involved legal suits. In other words, court orders. Later on, he did invoke the Insurrection Act to relocate troops, but Attorney General Kennedy, Robert Kennedy, said that what was going on was that the Alabama State Police were inflaming the situation. And in the end, President Kennedy never deployed federal troops. The second precedent is even clearer. 1 year later, when after the murder of civil rights workers in 1964, there was a request that the Kennedy administration commit federal troops to Neshoba, Mississippi. And Robert Kennedy declined to do so, saying he had to respect the state and local governments. A bunch of law professors asked for explanation, and the then Deputy Attorney General, later Attorney General Nick Katzenbach, wrote an opinion. And it was obviously written by the Office of Legal Counsel, where both Margie and I once worked, which says, a situation arises only when the state itself supports or encourages those engaging or threatening to engage in violence as a reason, and threatens their civil rights to justify invocation of the Insurrection Act in those circumstances. So there is no case in which troops have been committed because of a general lack of public order. Finally, it should be clear that were this the norm, that the president could commit federal troops over the objections of state and local officials, it would violate both the principle of separation of powers by concentrating executive power in the president, and it would be invasion of the police powers of the state under the 10th Amendment. Now, there are all kinds of cases that get cited by people like John Yoo. I just mentioned them quickly. Martin versus Mott, he cites as an example. Well, that was a foreign invasion. Luther versus Borden. Well, the state requested the assistance. The Prize cases, it was an invasion. In re Debs, it was an injunction ordered by the federal court. So if you actually read the precedents as opposed to make political arguments, you know that these precedents don't in fact support the claim of a widespread public disorder exemption. Finally, it's worth noting that Senator Dick Blumenthal, my senator, has introduced a reform bill to reduce the ability of presidents inappropriately to deploy troops to American cities. On the House side, Representatives Omar, Jayapal, Pocan, and Escobar introduced the companion measure. The Center for American Progress has also put forward an important proposal on Insurrection Act reform after Lafayette Square. But if there's one message that your listeners should take away from what I'm saying, obviously it would help to have clarifying legislation, but we don't need it. The existing terms of the Insurrection Act do not authorize any American president to deploy federal troops into US cities in the general name of restoring public order. And we even are now seeing political advertisements showing unrest in the streets. Increasingly, the president is switching from using federal troops to using federal agents, such as people from Homeland Security, and invoking claims that when federal buildings are threatened, you have a right to use Homeland Security without posse comitatus restraints. This seems to be clearly illegal. I wouldn't doubt that the Justice Department, this Justice Department, might issue a self-serving opinion allowing it, but I don't think we should believe it. So just to summarize again, the president doesn't possess legal authority to deploy US military forces against domestic protesters in civilian streets when it's over the objection of a state and local government, when it has nothing to do with a court order, and when it's not for the purpose of protecting civil rights, like the civil rights of James Meredith in Mississippi. Obviously, that's particularly true when introducing such federal troops would also violate the First Amendment, separation of powers, federalism, or the rights of individuals to be elected, to participate in elections. I think the law here is clear, and I hope that people at the city bar who have been so important on this rule of law issue understand this notion when broad and unsupported claims are made about the Insurrection Act. Finally, if you're interested in what I've just said, you're welcome to look at the American Constitution Society's issue brief, which is in fact something that I've written with one of my students, and it's there for your reference in case I move too fast. Thank you, Roger.
Professor Coe, so what happens if, in fact, the president does, order American troops against the wishes of local and state government to intervene in ways that clearly violate his statutory and constitutional powers?
Well, you go to a judge like Judge Rakoff and you seek a preliminary injunction. You say there's irreparable harm. You have a substantial likelihood of success on the merits. You point to the fact that there is no basis of authority and no basis of statutory authority and no basis of constitutional authority. And then you say it's against constitutional rights, which puts you into Youngstown Category 3, which means the president doesn't have the power. and you get a ruling against the president's power to do so.
Who has the standing to bring that lawsuit?
I think someone who would be going into the streets whose rights would be affected, their right to assemble. I think that's not that hard to establish.
Do you view that, does the military have any responsibility to abide by what it would understand to be a illegal order from the president?
Not only do they, I think that's what Mark Esper was signaling the day after Lafayette Square. He said, I'm not following the Insurrection Act because, and I don't favor its invocation. You know, Trump after June 1st was making all kinds of statements. And I think Esper put out a statement that we're not going to do this. His exact statement was, the option to use active duty forces in a law enforcement role should be used only as a matter of last resort, only in the most urgent and dire situations, and we're not in one of those situations now. Now, clearly he got some kind of legal advice to give that. That advice should have said, doing so is illegal, and for the Secretary of Defense to order it would be in violation of his constitutional oath. But this is why I started with my remarks. You know, I have huge respect for Judge Rakoff, who's a courageous judge. I have no doubt that a courageous judge faced with this kind of situation would find this is eminently judiciable. It's a legal question. Is the president acting under statutory authority or in violation of the Constitution? And then just make a clear ruling. You have a substantial likelihood of success on the merits, so I grant you a preliminary injunction and a declaratory relief at the same time. I bring that case myself with the help of Steve Cass.
Is there any role, Professor, for any federal authority if, in fact, a sitting president does not abide by the will of the electorate and refuses to leave office and seeks to invoke the powers of government to stay in office?
Well, you know, there's a lot of discussion about that, obviously, at this moment. And we have a president who has very widely indicated his willingness to violate, as Chuck has well put in many things, every conceivable norm about the rule of law. But just remember, everybody who surrounds him and facilitates his efforts has also taken the oath of office. And each of them has to independently decide whether they will do what Donald Trump wants or uphold the Constitution and laws of the United States of America. And we've had all kinds of examples. Obviously, it's been criticized as deep state. To my view, it's simply individual government officials following their sense of duty. You know, we see it with Sally Yates, we see it with Alexander Vindman, we see it with Fiona Hill, we see it with Bill Taylor. We see it with the attorneys in the Stone investigation who quit rather than participate in the de facto commuting of the sentence. You know, many of these people are career officials. They're not necessarily Democrats, but they took oaths too. And they understood that there were certain norms and they're not going to twist or destroy their own reputations just because someone wants to stay in power. After all, you know, this is not a dictatorship. The entire purpose of the Constitution was to facilitate orderly transfers of power. And George Washington did it when he could have been elected 1,000 times. So, you know, someone who's not doing well in the polls and has far less of a right to make such a claim.
So, Professor, last question for now. Would it be appropriate for the president to order, you know, U.S. troops, other federal organizations to intervene in situations where there are reports of violence at polling stations that is impeding the appropriate freedom of the ability to vote by citizens within that locality?
Well, absolutely not, for the reasons that I already given. There are federal laws against committing troops to polling places on election day because the hazard that in fact they will be invoked in the name of democracy, but in fact impede democracy is too great. You know, that's the kind of thing that happens in military dictatorship. You know, Roger, just to put it in lay terms, and Margie knows this well, you know, I came from Korea, South Korea, my family, and they had a military dictatorship there. And I remember very distinctly that when I was a college student, Richard Nixon stepped down under the threat of Watergate at the same time as there was an assassination attempt on the president of South Korea. There was martial law declared and troops were in the streets, basically to enforce military rule. And I called my dad and I said, isn't this incredible? The most powerful nation in the world just changed power with no tanks in the streets. And this country that you came from, we came from, has never had a peaceful transition of power. And he said, that's the difference of the rule of law and the rule of individuals. He said, in some countries, when you're president, the troops obey you, like the United States. He goes, in other countries, if the troops obey you, they call you president. And my feeling, frankly, is that if someone is no longer the legitimate president, there are too many people in this country who are real patriots to the Constitution, who will actually follow the Constitution, follow their oath, and obey the president who is, not the president who would like to be.
Professor, thank you very much. Our final speaker for today is Margaret Colgate Love, the Executive Director of the Collateral Consequences Resource Center. Ms. Love served as U.S. Pardon Attorney between 1990 and 1997, and since leaving public office has successfully represented numerous individuals with federal convictions in the clemency process. She also has advised individuals with state convictions on avoiding or mitigating the collateral consequences of conviction. And she regularly consults with legislatures, clemency and parole authorities, governor's offices, and other agencies and organizations. Ms. Love, please proceed.
Well, thank you very much. I am delighted and honored to be here, part of this illustrious panel, to talk about presidential pardons. And I understand the concerns that have been raised about what connection there may be between pardon and the rule of law. Actually, the framers intended there to be very little. As they conceived it, the role of pardon was to break rules. They also understood that the power to break those rules was beyond the control of the courts or Congress. This may explain why, when I was in charge of the pardon program at the Justice Department, my appearance on the 4th floor of Main Justice was generally greeted with nervous laughter and corny jokes. In any case, to get back to the framers, they expected, or most of them expected, presidential rule breaking to be done in a constructive and institutionally responsible way. As Hamilton explained it, the benign prerogative of pardoning was not the arbitrary and unaccountable power of an autocrat, but an essential adjunct to a criminal code that was necessarily severe and sometimes even cruel. Hamilton also argued that pardon had an overtly political role to play, helping the president to calm the jitters, national jitters, in what he called seasons of insurrection. Hamilton was confident that the power would not be abused in the hands of the chief executive, doubtless thinking of who that chief was likely to be in his own lifetime. But other framers weren't so sure. James Mason, one of the few delegates to the Constitutional Convention who refused to sign the document, was concerned that the pardon power might be used by the president to and I'm quoting here, screen from punishment those whom he had secretly instigated to commit the crime, and thereby prevent a discovery of his own guilt. But James Iredell of North Carolina was confident that no man honored in such a manner by his country would risk the damnation of his fame to all future ages. It is what it is. Throughout our history, the pardon power has been the unruly child in democracy's nursery, frequently employed to avoid the law or mitigate its consequences, though never threatening the rule of law itself. By and large, the power has been used responsibly by our presidents, despite their having only their honor and good sense to guide them in its exercise. But they had also something else. Beginning at the time of the Civil War, the president could also count on his attorney general to advise him in his pardoning, a role that effectively enlisted the power in the service of the legal system. Lincoln's first attorney general insisted that all applicants for pardon come first to him, since, he said, the soft-hearted Mr. Lincoln could not be trusted with the power. Lincoln's generals had complained that the president, importuned at his soirees by mothers whose soldier sons faced execution by court-martial, was frustrating the war effort with his pardons. And this is how it came to be that responsibility for administering the pardon power was effectively staffed out to the nation's chief law enforcement officer. This arrangement ensured pardon's peaceful coexistence with the rule of law until the beginning of this century. Of course, the power also had its political uses. The Nixon pardon, the Vietnam amnesties come to mind. And presidents also pardoned in cases where they had a personal interest. In some of those cases, pardons cut short ongoing prosecutions, like Reagan's pardons of the 2 FBI officials charged with civil rights violations, and George H.W. Bush's Iran-Contra pardons. But the meat and potatoes of the business of presidential pardoning were the hundreds of cases each year involving ordinary people in which the president shortened prison sentences or restored rights, all at the instance of his attorney general. And until this century, the system worked so well that there was never a true pardon scandal. The advisory system that allowed pardon and the rule of law to coexist until relatively recently was never made binding on the president. Because the system worked to everybody's advantage, there never seemed to be any need to formalize the kind of institutional gatekeepers and guardrails that many states employ to encourage a positive role for pardon in advancing the rule of law, or at least not frustrating it. The common law marriage of pardon and the rule of law began to come apart in the 1980s. I won't go into all of the reasons for this, but one of the most consequential was the Attorney General's decision at the beginning of the Reagan administration to delegate his advisory responsibility to his second in command, which at one stroke made pardon a bit player in the crime war, its exercise tightly controlled by federal prosecutors. The result 2 decades later was Bill Clinton's scandalous end-of-term pardon spree and Barack Obama's well-intentioned, but I would argue mishandled effort to single-handedly undo 30 years of mandatory minimum drug sentencing. Both of these episodes foreshadowed our present predicament, where it's the rule of law that is now the bit player in President Trump's pardon show. Far from acting as a brake on this president's unruly impulses, the Attorney General acts as an accomplice. It may surprise you that I think only 2 of President Trump's pardons are truly problematic from a rule of law point of view. Those are the pardon grants to soldiers prosecuted for war crimes, an unprecedented presidential intervention in the military justice system that sends a dangerous message outside our borders. All of the others, even the pardon to Joe Arpaio, have historical precedents and don't attack the system at its core. For the most part, however, it is the show itself that sets this president apart from any of his predecessors. And the power is exercised entirely without institutional or philosophical constraints at the president's whim. The saddest thing about that show, in my view, is that ordinary people who obediently filed applications through the long-standing Justice Department pardon process no longer have even the same shot at presidential mercy as the holder of a lottery ticket. It may also be surprising that I do not think the solution to this marriage gone bad is to try to coax pardon back into the tame and respectable role it once enjoyed as handmaid to the legal system, perhaps making arrangements to limit the president's power to pardon at will. In the first place, no responsible president would voluntarily relinquish any part of his power to a commission or otherwise. More important, pardon is simply too clunky and exposed a mechanism to operate effectively in the modern justice system. We have expected pardon to do too much. We've expected it to behave itself. This is why I see President Trump's provocative and unprecedented use of the power as a kind of gift, which offers both opportunity and incentive to consider why we need pardon at all, and to make the necessary changes in the legal system that will make pardon largely unnecessary to its equitable operation. Happily, we are already halfway there. Judge Rakoff knows what I am talking about, since just the other day he decided a case recognizing that the law has already been changed to reroute a substantial part of pardoning business into the courts, and under President Trump's watch at that. I'm referring to the provision in the First Step Act that allows courts to consider prisoner petitions for modification of their sentence for extraordinary and compelling reasons, instead of being dependent on a Justice Department motion. And there are bills now pending in Congress that would address the other part of the pardon caseload, authorizing the courts to restore rights and opportunities to those who have completed their sentences. This realignment of pardon and the rule of law would leave the president to deal with the truly exceptional situations that the law has failed to resolve, hopefully checked, as in the past, by a concern about the damnation of his fame to all future ages. In the meantime, and simply to wrap up here, I expect that we'll see some very unusual and likely unprecedented uses of the pardon power over the next 3 months. And I think I'll leave it there to see if anyone has any questions for me.
Thank you, Ms. Love. We'll first deal with questions addressed to you in particular, and then afterwards we'll open it up both to questions in general and perhaps participation from the speakers as to comments and questions amongst themselves. But the two questions that immediately jumped out from the participants in today's session are, it's two different persons asked the same question. Does the president have the power to pardon himself?
Why did I think that was that? That's like packing the court. Do I get to not? No, the answer to that question is no.
Why not?
Well, I think it's a rather complicated argument. If you really want to go back to sort of medieval political theory, the king's two bodies and all that stuff, I say no in a very cavalier way. It's the best way I know how to answer that question, just no. I think ultimately, if the president tries, there will be institutional upheavals. And I think that that is hopefully, there's another scenario, of course, which is that if the president loses the election, and if he feels in need of a pardon, he might resign and let President Pence do it. So that's the other possible Nixonian scenario.
Ms. Love, why did it not trouble you? Let me take a step back. You indicated that the pardons that troubled you the most were the ones directed at the military personnel. Did it not trouble you that the current president signaled to persons who were not yet finished with their the resolution of their criminal cases that he was willing to exercise the pardon on their behalves in situations that involved possible allegations against the president?
Yeah, sure, it's troublesome. That's precisely the scenario that Mason was concerned about. And it was actually mentioned in the Federalist 74 that where Hamilton discusses the pardon power. Yes, it's troubling. It's not entirely unprecedented. And there are external ways of controlling the president's power. I mean, there are statutes that bar bribery. There are other ways to punish exercises of the pardon power. However, I don't think that those external constraints, I mean, I shouldn't call them constraints. They are responses. I do not think that they constrain, because no matter how corrupt a president's exercise of his pardon power, the pardon itself stands.
Would you argue that there is a need, on the assumption that the pardon power is not revoked, would you argue that there is some need for some sort of civil penalty that might apply to an abuse of the pardon power?
Well, it depends what you mean by abuse. I mean, why should there not be a criminal penalty if it is truly abused? It really depends upon the factual scenario. I guess the point that I was trying to make is that there have been many historical examples of a president reaching into the justice system and sort of putting a spoke in the wheel, stopping the gears. It has never been thought to threaten the foundations of the republic. I don't think, as I said, that any of President Trump's pardons, even though they're annoying in the extreme in some cases, have the kind of institution-shaking implications that possibly his war crimes pardons do. And I suppose there are scenarios that one can think of that other pardons might also.
So at this point, I would like to open up questions from participants and from the other speakers to any of the speakers, and also invite any of the speakers to make whatever comments they would have on today's proceedings. Professor Coe, go ahead.
Just a question to Margie. The president could be, after he leaves office, can be prosecuted for using pardons to obstruct justice if it's a violation of the obstruction of justice statute. And if he's reelected, misuse of pardons could also be cited as a basis for impeachment.
Absolutely.
Even if he's already been impeached for actions to this point. When you look at what Andrew Weissman said about in his book about what he thinks Mueller should have done, it adds even more to that notion.
No, that's absolutely right. And that's I should have said that, because it was always assumed, the framers always assumed, that impeachment was the response to abuse of power. And as I also said, there are other statutory responses, I would say, to it: obstruction of justice, bribery, whatever. You can prosecute for a criminal exercise of the pardon power. I think my point was it doesn't bear on the effectiveness of the pardon itself.
Mr. Rosenberg, do you have any questions or comments about today's proceedings?
Yeah, I have thanks, Roger. I have a question for you, Margaret, as well. You said the answer, well, I guess I have two questions. One is you said the answer to the question, can a president pardon himself, is simply no. But I would like to know what happens, in your view, if the president does pardon himself and is not reelected. In other words, there are no grounds for impeaching a former president. My other question is, and this is sort of like your impression, Ford pardoned Nixon, and he was excoriated at the time, and testified in front of Congress, which is sort of a quaint notion. I can't imagine this president doing it, and explained that he pardoned Nixon because he thought there were too many problems that we needed to focus on, and he'd rather look forward than backward. Senator Ted Kennedy was one of those who excoriated Ford for the Nixon pardon, and a quarter of a century later gave an elderly Gerald Ford the Profiles in Courage Award at the John F. Kennedy Library. I think it was in the summer of 2001, and said he, Ford, was right, and I, Ted Kennedy, was wrong. I'm wondering, just normatively, what your view is as a nation. That so many people are calling for truth commissions and for the prosecution of Trump and other members of his administration. It seems to me, even though I'm a rule of law guy and a former federal prosecutor, that Ford was right. And I'd love to have your view on that too.
Yeah, I think that in retrospect, Ford's pardon of Nixon is seen as one of those seasons of insurrection, if you will, pardons that Hamilton foresaw, that to sort of calm national turmoil, national jitters, if you will, to spare the nation from the spectacle of a prosecution of the president. And so he took a huge risk politically. That's what presidents do. And I think he explained himself pretty well. And of course, in the fullness of time, in retrospect, most people agree that it was the right thing to do.
And Margaret, thank you. What about the first question? Putting us, let's say the president pardons himself but is not reelected, so you have no impeachment option. How actually is that challenged, and why wouldn't the Supreme Court, to sort of cite Judge Rakoff, perhaps consider that a political question and stay out of it?
Well, I mean, if the president pardons himself, first of all, I would say, for what? I mean, any federal crime committed at any time, or any crime to be committed. I mean,
no. Up to that point in time.
Right. So I think the response to that is to bring charges, is for the Justice Department to bring charges. And then, I'll see you in court. And I think you put it in the court, and are these righteous charges or are they not? And then the question of whether the president can pardon himself will be where it ought to be, which is in the courts.
Well, one of the participants asks the following question, which I think is a good segue to this discussion. So I'm going to address the question first to Mr. Rosenberg. Do you agree that the president is not subject to prosecution during his term?
I'll say it this way. I agree with the policy that the president ought not to be subject to prosecution during his term. By the way, that policy does not come out of this administration. It was issued first under President Nixon and issued a second time under President Clinton. So I agree. By the way, that's also the basis, Roger, for why Bob Mueller did not make a specific recommendation in his report. His thinking was that if you can't charge a sitting president and give that person an opportunity to defend himself in court, you ought not recommend bringing charges against the sitting president for much the same reason. So the policy makes sense to me, and Mueller's construction of it in his report makes sense to me.
But given your scenario, let's say President Trump, in his lame duck session, issues a pardon to himself. Under those circumstances, do you think that there should not be any action brought against the president for his actions?
That is a really hard question for me. I know that in these, you're supposed to always be absolutely sure of yourself and have a definitive answer for every question you're asked. I don't. I go back and forth. I mean, as a former federal prosecutor, it bugs the hell out of me. But again, I think, and to Margaret's point, and my question, I think Ford had it right. We have a lot of things we have to resolve as a nation. And I'd rather not spend the next 4 years talking about Donald Trump. So I have a hard time with that one. I don't know is the honest answer, but my inclination is to treat Trump the way Ford treated Nixon and to move forward.
Professor Coe?
Well, I think just an obvious point is that this is the city bar. Cyrus Vance Jr. Can obviously prosecute a former President Trump for state crimes, and Trump can't pardon himself for state crimes. And, he's already got a long-standing investigation going in which subpoenas have been done and upheld by the Supreme Court, at least in terms of his right to do so. So I don't think there's obviously a limit on how much Trump can try to protect himself by using a federal pardon power in this circumstance.
Well, Harold, I was interested to hear you say that a former President Trump. The more interesting question to me is, could Cyrus Vance prosecute a sitting President Trump? What do you think?
Well, recall that they didn't say that Bill Clinton couldn't be sued civilly for stuff that happened before he was president involving Paula Jones. If the claims against the sitting President Trump are based on, financial crimes that were committed before he's president, I'm not sure why he shouldn't have to defend that. And, if he has enough time to tweet 30 times an hour, then there's obviously time to answer the criminal process. I think it was made clear in the Nixon tapes case that the president is not exempt from answering criminal process.
Any other questions or comments amongst the speakers with respect to what we've been talking about today? Then let me ask the last question before putting Steve Cass on the spot. This is from one of the participants. In light of of your comments, are you concerned that if indeed it's appropriate to pardon a president in order to avoid continued strife within the country, doesn't that give future presidents carte blanche to commit whatever federal crimes they see fit to benefit themselves or those close to them?
Well, if this is for me,
yes.
I mean, I guess I would just, maybe I'm sentimental or some such thing, but I would rely on what James Iredell talked about and say that I would be confident that no man or woman honored in such a manner by his or her country would risk the damnation of his fame to all future ages. I think that if we stray so far from that notion of honor and duty in the highest offices in this country, we are in big trouble, bigger trouble even than going beyond the appropriate use of the pardon power.
Roger, can I just make a very obvious point?
Please. Yes.
Most pardons, as Margie knows 1,000 times better than I do, come after someone's been convicted. The Ford pardon came before any processes were initiated. But we have a situation where we now have reporting that the president paid no taxes, except for in 2 years paid $750. It's apparently the subject of an audit. This is also part of what's being pursued by Cyrus Vance. People are pursued for financial crimes and tax evasion all the time. It's not at all clear to me why, if a president has, one of the points that was made in the debate last night is, if the president owes all this money, who does he owe it to? If he owes it to various foreign entities, maybe that's the reason why his behavior toward those entities is as it is. So there's a truth-telling function of the prosecution that could play out, and then a decision to be made by the president's successor about whether the president actually goes to jail and serves sentences is later. There's no reason why Ford had to do, I mean, maybe Ford was acting on the exigencies of that particular moment, but that doesn't mean that presidential pardons have to happen before any action is taken for the good of the country. You know, after all, you might want to actually discourage people from, candidates from not paying taxes and then not telling people what their taxes are for 4 years. So there are all kinds of considerations that come into play, not just considerations about stirring unrest.
Steve Cass, I know that you have a question. You need to unmute yourself, Steve. Steve, you got to unmute yourself. There you go.
Yes, I did. But Roger, you asked my question. You actually did. And I did want to just go back to something that Harold Coe had said earlier, which is the pattern of abuse in other countries, in other dictatorships, where pardons are run of the course. Though I do note that the Supreme Court of Argentina found invalid amnesties and pardons given to the generals of the junta who had committed extensive crimes during a dirty war, notwithstanding the concern for public confidence going forward. They felt sufficiently important were the crimes of the past that the way to deter them in the future was to invalidate what they thought was an inappropriate and unconstitutional pardon.
That's very interesting. I have not seen that. I frankly don't think that the answer would be that the same under our own Constitution, for better or for worse. I mean, the massive Vietnam pardons, for example, might have been considered by some to be abusive. So I think we have to live with what we have and try to make better decisions ourselves about how we put people in office and who we put in office.
So Steve, in light of your having participated in the prior sessions, any thoughts on where we stand in terms of the sessions to date on the rule of law and what you're hoping to see going forward in the next two sessions?
Well, I would just want to start, Roger, by thanking you for your wonderful job as a moderator. And I think you've illustrated why you were such a wonderful president of the association. And thank as well all of our speakers today, Professor Fried, Judge Rakoff, both of whom have had to go to other commitments, but Margaret and to Chuck and to Harold, all for such thoughtful and interesting discussions on tough issues. I do want to say to our audience and remind you that we have two more sessions equally compelling for this forum. Our next session will be on October 21 at 1 p.m., where we'll be speaking about threats to individual and societal rights as a result of disruption of the rule of law. And our final session will be on November 18, when we will be discussing what lawyers and citizens can and should be doing to help rebuild the fabric of law within our society. So with that, I would simply like to thank you all again, thank the audience, and we look forward to seeing you next on October 21.